We're still in what I referred to as Block 1. Last week we heard from the Perth-based independent directors. This week, broadly speaking, we will be hearing from Perth-based executives and then move to executives from not necessarily Perth-based. So that's the broad structure of the rest of Block 1, and I think today we have Mr. Preston. Thank you, Mr. Preston. Would you state your full name for the record?
Joshua Robert Preston.
And do you wish to affirm or swear an oath?
Swear an oath, thank you. I, Joshua Robert Preston, swear by Almighty God that the evidence I shall give to this Commission shall be the truth, the whole truth, and nothing but the truth.
Please sit down, Mr. Preston. Thank you. Mr. Penglis.
May it please the Commission today, from today forward, I give Mr. Preston as opposed to witness I give for Friday. I do so today and tomorrow with Mr. Grondel, who is to my right.
Sure.
Mr. Preston, you've prepared 3 witness statements for the purpose of this hearing, have you not?
Yes, I have.
All right, let me show you these documents, if I may. Would you look at the first that I've provided to you? It's dated 29 July 2021. Do you, if you have a quick look at that, because I know you've looked at it very recently, do you identify that as your first witness statement dated 29 July?
Yes.
You look at page 89 up the top of the page numbers, last 2 numbers 89, is that your signature which appears on the bottom of that page?
Yes, it is.
I think you want to make one amendment to this statement. If you turn to page 3, up the top, which is a continuation of paragraph 9, I understand you would like to treat the words government and as having been deleted.
Yes, I would. Thank you.
All right. Subject to that deletion, do you confirm the contents of this witness statement to be true and correct to the best of your knowledge and belief?
Yes, I do.
Now, just also for the sake of completeness, there should be 3 documents attached to that witness statement. They have separate numbers up the top, but from page subsequent to page 89, do you confirm that they are the documents referred to in your witness statement?
Yes, they are.
All right, can you put that to one side? The second of the documents you have in front of you, this witness statement, is dated 29 July also. Is that correct?
Yes, it is.
And that's your signature on the second page.
Yes, it is.
And do you confirm the contents of that statement to be true and correct to the
Yes,
best
it
of your
is.
knowledge and belief?
Yes.
Come back to that if I may. The third witness statement you should have before you is a witness statement dated yesterday's. Well, it's not dated yesterday's, do you? Sorry, can I just have a moment? You should have a third witness statement there. What date does it bear, Mr. Preston?
1 August 2021.
And is that your signature on the last page of the statement?
Yes, it is.
And is the document attached there to the 2 documents, copies of the documents referred to in your witness statement?
Yes, they are.
And do you confirm the contents of that witness statement to be true and correct?
Yes, I do.
May it please the Commission, that concludes Mr. Preston's evidence in chief, but I seek orders that I think have been communicated to the Commission with respect to the second witness statement.
Right, well, I will note, first of all, I'll note the tender of the other 2. So the witness statement of Joshua Robert Preston dated the 29th of July 2021 bearing the identifier number JRP.0001.0001.0001 will be admitted as an exhibit. The further witness statement of Joshua Preston dated the 1st of August 2021 and bearing the identifier JRP.0001.0003.0001 will be admitted into evidence as an exhibit. And the document, confidential supplementary witness statement of Joshua Robert Preston dated the 29th of July 2021 and bearing the identifier number JRP.0001.0002.0001 will be admitted into evidence subject to the confidentiality orders which have been foreshadowed by Mr. Penglis. And those orders are these: that until further order, non-publication orders are made in respect of the entirety of Mr. Joshua Robert Preston's supplementary statement JRP.0001.0002.0001 and any transcript of any hearing regarding the contents of Mr. Preston's supplementary statement JRP.0001.0002.0001 such that they be made available in hard copy or electronically only to the following persons: the Perth Casino Royal Commission, the Staff Council and solicitors assisting the Perth Casino Royal Commission, and any legal representative of a party granted leave to appear in the Perth Casino Royal Commission. And the second order is that any hearing addressing the contents of Mr. Preston's supplementary statement JRP.0001.0002.0001 will be subject to confidentiality orders. Now, I understand that hard copies of that confidential supplementary witness statement will now be made available to the counsel for the parties who've been given leave. And I'm sure that the tenor of the restrictions on publication will be well understood.
May it please the Commission.
All right, thank you. Mr. Futrell.
May it please the Commission. Mr. Preston, with the summons you received from the Commission, you received a schedule of topics for a proposed witness statement. I understand that you have responded to those topics in the first witness statement you have given. Could you confirm that that covers everything you wish to say about each of those topics?
It covers everything that we had the time to respond to with respect to putting together the statement.
Okay, do I take it from the answer to that question that it doesn't cover everything you want to say about those topics?
It covers everything I want to say.
Okay. What I propose to do is to take you through predominantly the lengthier witness statement and deal with some issues of clarification and to some extent expand on some of them. Some topics may not strictly be dealt with in the substance of the evidence you've given, but there'll be matters about which you should have knowledge. Now, could I start just with your role in the... I'm going to refer to it as the Crown Group, and by that I mean Crown Resorts Limited and all of its subsidiaries. And I think your evidence is that you were employed between September 2006 and December 2020.
Yes.
And from January 2007 to March 2017, you were the Executive General Manager, Legal Services at Crown Perth.
Until, sorry, what
March 2017?
Yes, that's correct.
And when referring to Crown Perth, I have in my mind an idea of what that means, but there are different witnesses who have referred to it in different ways. When you refer to Crown Perth, or other people within the Crown Group refer to Crown Perth, what is your understanding of that term? Which entities or which companies fall within that description?
There's a number of companies that fall within that description, which is reflective of the historical structure of the corporate enterprise. So there's three predominant ones in the context of what I've described as Crown Perth, which would be Burswood Nominees Limited as the licence holder, also in the capacity as trustee of the Burswood Property Trust. There's Burswood Resort Management Limited, which is the manager of that trust, and then there's Burswood Limited, which is the sole unit holder of the trust.
Okay. Can I make one observation? You're speaking rather quickly, so for the transcribers you may need to try and slow down a little bit. And the other thing is you're very quiet, so if you could speak up a bit as well so that we get the full transcript, please. So to take it from that, answer that question then, that if you like, all companies within the Crown Group that fall under Burswood Limited, the unit holder, would effectively be described as part of Crown Perth.
Yes, I would agree with that.
Now, you were in a position as the Chief Legal Officer of Australian Resorts from March 2017 until the end of last year, correct?
Yes.
Now, as I also understand it, throughout the entire period of your employment, again, I use the expression, with the Crown Group, the company Burswood Resort Management Limited was your direct employer.
That's correct.
Now, in your role as the Chief Legal Officer of Australian Resorts, you had responsibilities for Crown Perth and Crown Melbourne.
Yes.
And did that also include at this stage, yet to be opened, Barangaroo development for Crown Sydney?
Yes, it did.
All right. Now, your responsibilities included legal, regulatory, compliance, risk, responsible gambling, and AML CTF, correct?
Yes.
Now, you also had, for a time at least, some responsibility for security and surveillance at Crown Perth.
Yes.
I think you said that ceased in 2017.
It did.
Was that as a consequence of you moving into the role of the Chief Legal Officer for the Australian Resorts, was it?
It didn't cease immediately, but it ceased relatively shortly after I commenced in my role as the Chief Legal Officer.
Okay, and who took over the responsibility for managing that function after you ceased to have it?
Lonnie Bossy.
And Mr. Bossy was the Chief Operating Officer at that time of Crown Perth, correct?
Yes.
Okay, now, you were also Crown Perth's designated AML CTF Compliance Officer from November 2007 until you left the employment of the Crown Group.
Yes.
And you were Crown Melbourne's designated AML CTF Compliance Officer from May 2017.
Yes.
Again, until you left. Can I ask? You have obviously there's a number of pages of your statement that deal with your role, and can I just ask you to look at a document where we've tried to set it out in a pictorial way because there's so much information. It's PCRC.0010.0001.0001, which is essentially an aid memoir. And if I could invite your attention to it, because I would just like to confirm its accuracy largely. There are some initials on it, and these initials appear in a pink or purple colour. And I just want to identify those, the people who are represented by those initials. So if we could start, perhaps at the easiest place is down the very bottom, and in the box, Burswood Resort Management Limited, Company Secretary with Manos. That's Ms. Manos, and that was a role that you performed. There are some initials next to it, directors including KB, BF, JA, RC. The initials are for Mr. Ken Barton, Mr. Barry Felsteed, Mr. John Alexander, and Mr. Rowan Craigie. Now, just before I go on, I want to explain something to you. This is not intended to be a point-in-time representation. So, for example, with respect to Mr. Alexander and Mr. Craigie, it represents that they sat on that board at times that each of them were, in the case of Mr. Alexander, the Executive Chairman of Crown Resorts Limited, and in the case of Mr. Craigie when he was the CEO of Crown Resorts. So it's really intending to show over a period of time the companies upon which you were an officer, as in the company secretary, the roles that you played as part of the executive, and the individuals who sat on those entities with you. So just to understand a little more about the structure of the Crown Group, which is you see at the very top of the page, Crown Resorts Limited. When I asked you a question, you confirmed earlier that you had some responsibility for Crown Melbourne, in the same way that the description Crown Perth describes Burswood Limited and its subsidiaries, is it correct that Crown Melbourne describes Crown Melbourne Limited and its subsidiaries?
In essence, yes.
And would the same apply for Crown Sydney?
Yes.
Okay. Now, and again, this is a point in time, so we're only speaking about the period during which you were an employee of the Crown Group, or up to the time that you left. The expression Australian Resorts is used to describe a number of roles, or it's the last tag associated with a number of roles. What was meant by Australian Resorts?
What was meant was those roles were involved in the operations, as opposed to the corporate group, being Crown Resorts Limited from a corporate perspective. and it was an identifier that Australian Resorts was looking after essentially the 3 casino properties in those businesses.
Okay.
So for example, if I can assist,
Yes.
the Chief Finance Officer, Australian Resorts, was the lead finance person for Crown Melbourne, Crown Perth and in due course Sydney, whereas the Chief Finance Officer, Crown Resorts, was the Group Corporate Chief Financial Officer. So it's a designation to identify the difference in roles.
I see. So, broadly speaking, would it be correct to say then Crown Resorts is an operational function, and Crown Resorts, if I said that correctly, Australian Resorts is an operational, and Crown Resorts was the more of an administrative function in head office. Is that the general breakdown?
I wouldn't describe it as administrative, but it was the corporate office.
Corporate office.
Yes, Australian Resorts was more focused on the operational elements of the casino businesses.
All right. Now, in terms of function, then, was the function divided between, broadly speaking, between the operational function and the corporate head office function? So, for example, probably easy to do it by way of exclusion. What functions were held by the Crown Resorts office?
As an example, as I look at this table, they had their own risk framework, so they would deal with the corporate risk profile. Crown Resorts office would deal with any ASX and corporate structure related issues. That wasn't within the remit of the Australian Resorts roles. It would oversee the various other businesses associated with Crown Resorts, which were reasonably extensive. So a function of overseeing those roles as well, is the best way to describe it.
Where did Treasury sit? Where was that?
Treasury with the Crown Resorts as well.
Okay. Now, so was there the Chief Financial Officer, Crown Resorts, ultimately responsible for the Treasury function of the Crown Resorts Group?
Yes.
And was there any Treasury function associated with the various locations, the sites?
No. They would use the services of the Crown Resorts Group, as I understand it.
All right. Now, can I focus? I want to focus back now onto the Perth aspect of the structure. So that would be the operational function of the Perth casino. Well, perhaps before I do that, you reported to Mr. Felsteed as the CEO of Australian Resorts, correct?
Yes.
And he reported to the Chief Executive of Crown Resorts.
Yes.
Did you have a direct reporting line at all yourself directly to the Chief Executive of Crown Resorts?
No. However,
Yep.
in my capacity as Chief Legal Officer, I had a direct line of report to the Executive Chairman, who was the chair of the Crown Perth companies and also the Crown Melbourne companies, who was also the Executive Chair of Crown Resorts.
So, sorry, can you repeat your answer to the question? I just didn't quite catch the...
So I didn't have a direct line of report through to the CEO or Executive Chair of Crown Resorts as a role.
Yes.
But I did have a direct line through to the chair of the Crown Perth boards and the Crown Melbourne board. It happened to be the same person.
Yes. Okay. I was going to ask you that. So, in effect, the executive person occupying the executive function of Crown Resorts, whether it be the CEO when Mr. Craigie was the CEO, or Mr. Alexander when he was the executive chair, or anyone else who occupied that role, the same person sat with you as a director of each of the operating companies within the Crown Perth Group.
Correct.
Sorry, can I just ask a question? Because I just want to ascertain in that corporate structure that you've been describing, but particularly between the responsibilities between Australian Resorts and Crown Resorts, from what date did that occur? was it in place?
I'm unsure. The first time I saw the Australian Resorts reference was with the appointment of Mr. Felsted as the Chief Executive Officer of Australian Resorts, because that was the first time I can recall a group function at the executive level coming into existence. And from then it was seemed to be the path of those group functions that the business had an appetite for over a number of years.
And secondly, was when that became the company structure, corporate structure, was there any document that put it in place and told people or told the entities what their roles were?
Not to that detail that I can recall, but what I do recall is certainly a note to the operating entities articulating that there was a new role, which was the compression of two previous CEOs of the individual properties into one role. And the individual properties and the executives from each property would be reporting into that single Chief Executive Officer of Australian Resorts.
So when you say you don't recall, but you recall it sort of coincided with Mr. Felsted's appointment to that senior role, CEO role in Australian Resorts, I suppose we could work that out by when he was appointed to that date, to that position. But do you have sort of early 2000, late 2000?
Oh, no, it was, from memory, 2012 or 13, in that range.
Thank you, Mr. Preston. Sorry, Mr. Future.
May it please, Commission. Mr. Preston, so I could just, if I may summarise the effect, I think, of what we've just been dealing with. And obviously, you can correct me if I'm wrong, or you feel free to disagree with me. So, is it the case that in respect of all of the operating entities for the Perth Group, there was a representation on the board by the most senior executive of Crown Resorts, being either the CEO or the executive chair?
That's correct.
In addition, each entity had the two most senior had the most senior executive of what you've described as the Australian Resorts, the operational arm, being Mr. Felsted.
Yes.
It also had the most senior executive dealing with the finance role, the Chief Financial Officer, Mr. Barton.
Yes.
And in the case of yourself, the most senior legal officer for Australian Resorts as the company secretary.
As the co-company secretary, yes.
Co-company secretary with Ms. Manos, who was also the secretary of Crown Resorts.
And General Counsel.
And General Counsel,
yes.
Right. But potentially whoever was in her role before her, if there was one.
It was Mr. Nielsen, and
Yes.
Ms. Manos replaced Mr. Nielsen.
And that structure was repeated for each location, I take it, so that essentially the same structure was repeated for Crown Melbourne and for Crown Perth and then for Crown Sydney.
Crown Sydney, yes, for Crown Melbourne and Crown Perth. Crown Sydney was still being formed towards during the course of 2019 and 20, and it was forming up in a different manner to that which the Perth and Sydney historical structure was in place. It was something a little bit different.
When you say a little different, does that mean that the most senior executives were going to be different people, or were they the same people?
The executives were to be the same people, but the actual board structure was taking on a different form. If I'm not mistaken, it was taking into account a number of the Crown Resource directors who were going to be sitting on that board and chairing that board from recollection.
I see. So that at the if I could put it this way, at the head of the group, the Crown Sydney Group, the equivalent of Burswood Limited, it was going to be constituted in a different way, the membership of that board.
As I recall, yes, it was one of the Crown Resorts directors, not being the chair of Crown Resorts.
So just dealing then with the composition of the board at the head of each location. I know you've said Sydney was a little perhaps in a state of progress and hadn't been finally settled. In the case of Perth, it comprised the three executives we've dealt with, the most senior executive of Crown Resorts and the two effectively most senior executives of Australian Resorts, and yourself as the legal officer, and Ms Manos, the General Counsel's co-secretary, and two other directors who were not executives.
Yes, if I can just clarify one piece. The two most senior Australian Resorts executives, it was one most senior Australian Resorts executive, the CFO, if you're referring to the CFO, it was from Crown Resorts, not Australian Resorts. So Mr Barton was with Crown Resorts.
Oh, I see. Thank you for clarifying that. So he was the most senior financial person in the Crown Group.
Correct.
I see. So you had the two most senior, effectively executives in the Crown Resorts group who sat on each of these boards, plus the most senior executive of Australian Resorts.
Yes.
I see. Thank you for that. Now, insofar as Burswood Limited was concerned, there were two directors who were not also executives of the Crown Group during the period that you were involved in Crown Perth. I think for most of that period it was Mr Poynton and Mr Roberts, correct?
But most of that period, yes.
And then towards the end of that time, Mr Roberts resigned and was replaced by Ms Fuster.
Yes.
So it's the case, isn't it, that throughout that period, in effect, in respect of any decision that the board of Burswood Limited was called upon to make, the executive team, if I could put it that way, of the Crown Group would always carry the day, correct? Had 3 of the 5 members.
They certainly have the numbers.
Now, coming down one step, if I could, just to understand how, and I'd like you to explain to the Commission really something that is not entirely clear from reading, we've read all the minutes and the corporate structures, etc. We really would like to understand how this group in Perth operated in a daily way, and the corporate responsibilities for those functions. So I think we've mentioned earlier that Burswood Limited was the unit holder of the Burswood Property Trust, the sole unit holder of that trust, of which Burswood Nominees was the trustee. You're nodding, you're nodding.
Yes, sorry.
Burswood Limited also was the shareholder of Burswood Nominees, correct?
Yes.
So, what exactly was the business of Burswood Limited in your view?
Well, I might start with saying it was an historical structure that had been in place for a long period of time, and it was operating collectively between my observations and from my experience was they were operating as one. Burswood Limited, Burswood Nominees Limited and Burswood Resort Management Limited. Burswood Nominees Limited was always recognised as the operator, as it held the licence. In the context of the function from a board perspective, Burswood Limited board was the board of moment. It was the board that had the quarterly meetings, full board meetings. The other 2 boards, the subsidiary boards, they didn't meet. But having said that, each of the directors on the subsidiary boards were part of the composition of the directors of Burswood Limited. So in effect, the matters were being considered by a greater number of people, including the independent directors. and it was making decisions, but Burswood Nominees Limited recognising the fact it was its own company and it had its own board, but it was all business dealt with, generally speaking, at Burswood Limited.
So, do I take it from that answer that we could call it the working assumption of the people in Crown Perth was that Burswood Limited was the company that made the key decisions associated with running Crown Perth?
Well, it was making decisions through the function of the board, but again, the Burswood nominees operator directors were part of that board, and my expectation is if there were any issues, they would have raised issues. But I recognise the fact that they were also sitting on the Burswood Limited board and privy to the various discussions that were taking place and the decisions that were being made. If there were specific resolutions required of Burswood Nominees Limited, then the process would be followed, and they would duly undertake that decision-making process and deal with it by way of resolution.
All right. So, look, I'm just trying to understand, really, I mean, obviously, understand you're a lawyer by background, by training. Do you presumably you still a practicing certificate, or at least you're...
I do.
So you no doubt understand the structures probably better than many other people who will be witnesses in this commission. What the commission would like to know is what specifically Burswood Limited's function was in the Perth Crown Perth operation. So I understand you've said in answer to the earlier question that there were independent directors on it. There were reports being made to it, but specifically, what was its function? What was it doing as part of its corporate responsibility?
I'm not for a minute suggesting it's a clean structure. It's a complex structure and one that's been in place a long period of time, well before I started, for what that's worth. But my views in terms of Burswood Limited is that it was dealing with all of the matters pertaining to the operation of Crown Perth, to the extent that it was a board, again, of the moment, I use that term because that to me describes what it was. And it was considering issues, it was understanding relevant information related to the operations, and it was providing feedback. From a governance perspective, it was acting in the interests of Burswood Limited, as you would expect. But again, sitting on that board with the Burswood nominees directors, they weren't having separate meetings. They were participating in the discussions. So in effect, it was operating as one. Collectively, they were considering the issues for Crown Perth and addressing them and making the relevant decisions.
All right. So, to your knowledge, who appointed let's take Burswood Nominees to begin with. So Burswood Nominees is the licensee of the Perth Casino. Throughout this period, its directors were, as you've dealt with in your evidence, the executives of the Crown Group, and in particular Australian Resorts. Now, who appointed them in their positions as directors of Burswood Nominees?
I'm unsure who appointed them. That was a matter that was dealt with during through Crown Resorts. Crown Resorts would deal with the appointments of directors and corporate structural issues.
Okay, so going back to the division of function, if you like, we just started with a little earlier, where Crown Resorts has the effectively the structural responsibility for the group, is it your evidence that a decision would be made by someone representing Crown Resorts, the group leader, and that would then be implemented to place people into the appropriate positions on subsidiary boards?
Certainly, as I understand it, and the changes to Burswood Nominees and Burswood Resort Management Limited were largely as a result of resignations of directors from the company. But yes, I would say that is how the appointments occurred on Burswood Nominees Limited and Burswood Resort Management Limited. With respect to Burswood Limited, the only change apart from executive composition, for example, when Rowan Craigie resigned, was the more recent appointment of Ms Fuster, which, if I recall correctly, went through for consideration, I understand, through discussion with board members of Burswood Limited.
Okay, now, for a considerable period of time, you were the company secretary of Burswood Limited.
Yes.
I take it in that role you attended the majority of the meetings.
Yes.
And was it part of your responsibility to be the person who prepared or oversaw the preparation of the minutes?
Yes.
And in your role, and during the period you were a company secretary, were there occasions when the subject of appointment of directors of Burswood Nominees, or Burswood Resort Management for that matter, discussed during board deliberations of Burswood Limited with the independent directors?
Not that I recall.
So is it your evidence that, so far as you can recall, there were no discussions involving the independent directors about who would become the directors of the subsidiary companies?
Not that I recall.
Okay, now when you say not that you recall, is it simply you don't have any recollection at all, or are you indicating it's something you think you would remember, but you don't?
I can't recall any discussions about the directorships on those subsidiary companies at the Burswood Limited board.
And is that because, in effect, the decision was made by Crown Resorts and then really just implemented by the various subsidiary companies that were required to do it?
I can't answer that. I can't answer exactly what Crown Resorts did or didn't do, but having a look at the individuals involved, the only change that I can recall during my time involvement with the Crown Perth boards,
Yes.
Was the resignation of Rowan Craigie,
Yes.
and then the appointment of John Alexander, who became the executive chairman of Resort and also the chair of Crown Perth.
Yes.
So that was the only real change. So
Yes. Yeah, understand.
concept recalling a discussion about that, I can't recall.
All right. Now, when dealing with the day-to-day affairs of Burswood Nominees, before I deal with that, actually, could I just ask you another question about Burswood Limited? Burswood Limited had no employees of its own, correct?
That's correct.
And so, when you started at Crown Perth, or use the group not name, who employed you?
Burswood Resort Management Limited was the employer.
And was there a contract of employment between you and that company?
Yes, there was.
And who was responsible for the presumably as your roles changed, who was responsible for negotiating the terms of your agreements with Burswood Resort Management?
It would have been Barry Felstead.
And he,
Sorry, in conjunction with the Human Resources Department in its
Right.
normal capacity.
and to your knowledge, and again, if you don't know, you don't need to answer this. Was Barry Felstead also employed by Australian Crown? Sorry, I'm getting my names confused. Mr. Preston, was he also employed by Burswood Resort Management?
He was historically, and then at a point in time he became employed, I understand, by Crown Resorts Limited.
All right. So, and can you put a date or a range of dates around that?
No, I'd be speculating.
All right. Would it was it earlier than, just in terms of chronology? Was it earlier than your appointment as the Chief Legal Officer of Australian Resorts?
Yes, it would have been.
And was he responsible for your appointment as the Chief Legal Officer of Australian Resorts?
It was a combination of Mr. Felstead and Mr. Alexander.
I see. So the decision to promote you to that position was made by the Executive Chair of Crown Resorts and Mr. Felstead, correct?
Yes, in what capacity Mr. Alexander was appointing me, that I couldn't answer that, but they were the two who were involved with the discussions with me about the new role.
And when your role changed, was there, perhaps we could start with your initial role first. I think you mentioned there was a contract of employment. Was there any document that set out your role, functions and duties from time to time?
Sure, I had a position description.
I see. And who was it? I take from your earlier answer, was that a document prepared by Human Resources and or with the assistance of Mr. Felstead for Burswood Resort Management?
Yes, it would have been in that structure, yes.
And when your role changed in 2017, was there a change in the job description, as it were?
Yes, there was.
Presumably you've received some sort of formal letter or notification, did you, of the appointment?
I did.
And do you recall from what entity or which company that that document came?
No, I don't.
Were there, as part of your role, were there annual reviews?
Yes.
And in the course of those annual reviews were, the modern expression is KPIs, but performance targets set
Yes.
for you. And were they set in a collaborative way with Mr. Felstead?
Yes, they were.
And to be clear, I'm really focusing here on the period after his appointment as the Chief Executive Officer of Australian Resorts. They were effectively set by him in that role.
Yes, they were.
Sorry, yes. In respect of your, I'll come back to that. I've digressed somewhat from dealing with Burswood Limited. At the operational level for Burswood nominees, the licensee, did it have any of its own employees?
No, it did not.
So do I understand it to be the case then that all employees are carrying out a function for the Perth Casino, and by that I mean all of the things, including hospitality and other things, were employed by by Burswood Resort Management, to your knowledge?
By and large, yes.
And when you say by and large, are you referring to people who might be on secondment from other Crown Group companies?
Well, there's a couple of areas, one of which would be your standard contractor base.
Yes.
That would be employed through employment companies with, for example, large numbers of casuals working in the conventions area.
Yes.
But then there were group employees, and depending on where the group function, and this was just an internal position, depending on where the group person was domiciled, that would be the employment company. So it was a group role that sat at Crown Perth. Their employer was Burrs Resort Management Limited, but they would provide services to Crown Perth and to Crown Melbourne. If they were a group person who for domiciled in Melbourne, they would provide services to Melbourne and Perth.
All right. Now you've reminded me of something. I wanted to ask you, which is the expression group. Is group used to signify Crown Resorts Limited, as in the corporate function we were discussing earlier, alone? Or does it mean, if it's a group role, it can mean Australian Resorts as well?
I use it in the context of Australian Resorts.
I see. So a group role, the designation group, like group manager AML, for instance, refers to a person who holds a position within the operational structure, Australian Resorts.
Yes.
Again, just to understand how matters worked on the ground in Perth then, I think you've said there were no formal meetings of directors of Burswood nominees, and I take it the same applies to Burswood Resort Management?
Yes, save for those meetings that were held by circular resolution for Burswood nominees.
I see, yes. Now, from a legal point of view, Burswood nominees had a business, correct?
Yes.
It's the licensee of the Perth Casino?
Yes.
And it owns the land upon which the casino and other structures are built?
Yes.
And Burswood Resort Management is the employer of it's effectively a service provider, I take it.
Yes.
It provides the services to the licensee, Burswood nominees.
Yes.
So in terms of Burswood nominees discharging its statutory or regulatory obligations, I take it you're familiar with the Casino Control Act and other legislation that is a legislative framework. Is it the case then that the individuals, the humans who are performing and discharging those roles were all employees of Burswood Resort Management?
Yes, they were.
And ultimate responsibility for their management, we say not ultimate, but in terms of Perth, the most senior executive was Mr. Felstead.
Yes.
Now, somewhere I won't take you to it unless you cannot recall. In your statement, you made reference to, and I think you have mentioned one or two occasions that this was an inherited structure, or when you arrived at Crown Perth. You have mentioned in passing the possible existence of some sort of agreement involving Australian Resort Management and Burswood. Sorry, getting the names confused again.
With you.
Yes. Burswood Resort Management and Burswood nominees, did you have in mind an agreement you cited when making that comment?
Yes, I recall seeing a document which was provided high-level commentary pertaining to the manager providing services to the trustee for it to carry its functions. And that might not be the language, but I recall seeing a document some considerable time ago. I haven't looked at it or considered it for a long period of time, which provided that kind of language.
All right. So in your role in any of the roles really you dealt with Crown Perth, did you familiarise yourself with the principal instruments that under which the Perth Casino operated?
I would have over time, yes.
So, for example, I take it you would have familiarised yourself with the state agreement.
Yes.
Were you also familiar with the Burswood Property Trust deed?
Yes.
Is that the document you have in mind that divided responsibility between Burswood nominees and the manager, or was it some other document you had in mind?
That rings a bell, but again, it has been some many years that I've looked at that document in depth.
All right. Now, could I ask you? Just want to come back to the employment structure. Were you eligible, or was part of your remuneration, did it involve any incentive plans or incentive structures?
Yes.
What were they? What were you entitled to?
There was a short-term incentive plan, which entitled me to a bonus depending on performance, a combination of my performance and Crown Perth's performance. And then there was a long-term incentive plan, which was a broader plan which took into account the performance of the group.
Okay, now the group, again, are you referring there to...
The Crown Resorts group.
Oh, Crown Resorts proper rather than Australian Resorts?
Yes, there was various mechanics within it.
Yes.
The detail of which I haven't looked at for some time.
Yes, I want to deal with it at the level of generality, really, just to understand. Now, were you eligible for those? Were all employees eligible for those incentive schemes, or only executives?
All employees. Not all employees were entitled to bonuses and incentive schemes. It was, generally speaking, management level and up. The long-term incentive scheme was a scheme for a smaller number of people, largely the executive line.
I see. And the long-term incentives, was that in the nature of options and shares and things of that character?
Yes.
Insofar as the short-term incentive is concerned, you mentioned performance. Was the primary component of that financial performance of Crown Perth?
That was a key component. It wasn't, I would describe that as the primary, but it was a key.
Okay, so just to give, again, this is at a level of generality, just to give the Commission a sense of how it operated. Was eligibility discretionary on the part of a person higher up in the structure?
Ultimately was discretionary. But generally speaking, in my experience, if you met your targets and the various targets that were being met were met, then an incentive would be provided.
All right. Now, in terms of targets, just again to give us a sense of what we had, what was in view, were the targets in light of the many roles you fulfilled? Were some of those targets directed to performance in for example, area of compliance?
Yes.
And what was the nature of those targets that you were to achieve in your compliance area?
Depended on the areas. They had specific health and safety, for example. They had obviously a heavy focus on health and safety compliance in carrying out their roles. But there were, as I recall, a number of compliance-related KPIs, compliance with policies, compliance with health and safety for all staff. But aside from that, we introduced a more recent general compliance specific KPI across the board, and that had been introduced relatively recently.
All right, if you could start with health and safety, because that's something I think we all can understand and relate to. So I presume, based on the common process, that the KPIs in that area would be determined by reference to lost time injuries and things of that nature that can be measured over a period, and then either targets met or targets not met. So if you're responsible for health and safety, for example, you can see where that target has been met in that year. In the case of compliance, what was the nature of the target, the kind of measure that was used to identify if you had met the compliance target?
I can't recall specifically, but we had this is for Crown Perth, quite a mature compliance framework where various compliance weaknesses or failures were recorded on through monthly compliance certificates. So if I recall correctly, the analysis was undertaken as to failures, rectifications, and performance in that context, from determining whether it's compliant business unit or the person who's been tested. They were doing their job from a compliance perspective.
I see. Now, in your particular case, did that include any aspect of the AML CTF program?
It would have. Each of the departments had various compliance mechanisms to report on, including AML and including all the departments.
All right. Now, you also had a role in responsible service of gambling. I think you chaired the Perth committee for that at least one stage.
I think for a period I chaired it, but responsible gambling reported through to me ultimately.
And
Sorry, I didn't hear that.
Sorry, responsible gambling did report through to me for a longer period.
Thank you.
And so, in terms of the KPIs for you, was there any inclusion in that of targets for responsible service of gambling?
Not specific targets.
When you say not specific, well, obviously it was a component of your management responsibility. How was performance measured for that on an annual basis?
For that area, like a lot of my areas, it was a KPI pertaining to having in place, driving a responsible gaming, positive culture, ensuring team structures were fine. I can't recall the specifics of my KPIs, so they were relatively lengthy from time to time.
So, just with respect to responsible service of gaming, how was, for example, the culture measured? How was your immediate manager, Mr. Felstead, to determine if you had met your target for instilling a culture of in that regard?
Mr. Felstead was quite involved in the responsible gaming framework as well. He took a keen interest in it. Mr. Felstead also participated from time to time in the Responsible Gaming Management Committee meetings. And through those meetings, which had most probably 20 senior managers in the business, there would be a discussion regarding statistical performance, There would be a discussion regarding initiatives. There'd be a discussion regarding issues. So Mr. Felsted had a first-hand experience of what that looked like. And I would suggest, but it'd be a matter for Mr. Felsted, I'd suggest that he would get a very keen sense of the responsible gaming framework and how it applied to Crown Perth from a cultural perspective, an embracement perspective, during the course of those meetings. Mr. Felsted also sat on the Crown Resorts Responsible Gaming Committee management meeting, so he had a very keen understanding of where Crown Perth sat in terms of its commitment to responsible gaming and its framework.
So, can I ask you then, were there any statistics that you measured with respect to had an application for responsible gaming that were targets that were set each year?
No.
So, in order to measure performance in that area, how precisely was it measured?
We would look at the statistics pertaining to a range of data, number of self-exclusions, number of revocations, number of breaches of self-exclusion, number of concerning behaviour reports that were lodged, details between people expressing problems with their gambling in machines versus tables, age demographics. So there was a range of statistics that were looked at, and we would analyse those statistics to understand if there were spikes or if there was a change in the nature of the statistics, to understand why, so we could react to it.
All right, so would it be fair to say then measuring performance in that area was not a quantitative exercise but more a qualitative one?
I would agree with that in the context of your initial question pertaining
Yes.
to performance generally.
And that I understand from part of the answer to the questions I've been asking is that because Mr. Felsted and yourself were involved in the responsible service of gaming committee structure, he was observing your involvement in that on a day-to-day basis firsthand, or whenever that committee met and in your reporting to the committee.
That and Mr. Felsted's engagement with staff generally who are involved in responsible gaming, and the various executive risk and compliance committee meetings where these matters would be discussed.
All right, so can I go back to an answer you gave a little earlier to the question I asked about incentives, and I think I may have phrased it as that financial performance was a key component or something. Where's that effect? And you responded by saying, making it clear that it was a component, but it wasn't perhaps the only component or key component.
I think the expression, just so we can get it right, was the question was it a primary component? And the witness answered no, but it was a key component.
That's my recollection.
Okay, thank you. So however one describes it, it's easy to measure in the sense that financial performance can be measured relatively easily. In what way was it a factor in the decision as to whether or not you received a short-term incentive at the end of the financial year?
The KPO framework was out of 100. You'd have a certain allocation from a financial performance perspective related to the company, Crown Perth.
Yes.
You'd have a certain financial performance related to the budgets that you were responsible for. So in my case, they were non-revenue driving budgets. They were all overheads, as you'd expect. And then there would be a percentage in terms of the areas that I was responsible for.
And was there a division between, if you like, overall performance, Crown Resorts, and a weighting for that?
Not for the short term.
Not for the short term.
No.
I see. So in your case, then, given that your role spread itself across the Australian Resorts Group, as in at least 2 operating locations at this time, was part of your in short-term incentive package the performance of Crown Melbourne as well?
It became relevant from 2017 onwards, yes.
So in part, your incentive related to the financial performance of what we call Crown Melbourne and Crown Perth, and do I take it within each of those structures? I might need to come back to the diagram. When the budgets for which you were responsible were largely in Perth, is that right?
They were all in Perth prior to 17.
Prior to 17?
Yes.
And then after 17, were there components in
They
Melbourne?
were a combination.
I see. And your, as you say, there were non-revenue generating areas, so performance was measured against costs incurred, was it?
That was if I was within my budget. That was set at the beginning of the year.
Mm-hmm.
That was an element of the short-term incentive plan.
Okay, so within the budgets under your control, then, was responsible service of gaming one of those?
Yes, it was.
And what was the process by which the budget was set for responsible service of gaming?
The process would be you'd build on each and every year, and you would analyse the current staffing levels, any upcoming initiatives for the new financial year, any increases in salaries that were expected or increase in resources that were expected, and you'd build them into the budget and seek approval from those who approved.
And who are those who approved the budget?
It was a committee, if I recall, comprising Mr. Felsted, Mr. Barton, I think maybe Mr. Barton, the CFO of Australian Resorts, and Human Resources had input as well, and that would be ultimately determined from that level, and they would approve it or not.
All right, so just to understand the budgeting process a little more, was there any parameters set prior to you working out how you're essentially going to, or put it this way, were you given an allocation from Crown Resorts, and then it was up to you as to how you would utilise that? Or were you in a position to go to Crown Resorts and say, this is how much I need for responsible service of gaming?
It would normally be a process where we would, so Crown Perth would be given a parameters of what the budget would look like for the following year in terms of what increases the company was willing to afford the operational areas, and you'd work within that budget as best you could. But in my experience, each and every department would come in with a budget over what they would ultimately get. They were looking for new incentives, new initiatives and more money for their departments. Then there'd be an analysis as to priorities, and then the budgets would be presented down to those.
Okay, so just in terms of the parameters that were set for each operating area, then were they broken up? The question really is whether an overall amount was allocated to Crown Perth, or whether an indication was given to each area.
It was an overall allocation to Crown Perth.
And so then when it came to setting the budget for a particular area of your responsibility, were you given parameters before that process began by someone within Crown Perth?
Yes.
And who was that?
It would normally be information provided by the CFO, who would circulate a note to the executives and general management team as to what the expected, for example, salary increase you could work within, and depending on the staff members and their performance, they would get increases to one degree or another.
I see. Now, the CFO use the period during which you were responsible for Australian Resorts. The CFO for Crown Perth at that time was who?
It was a CFO of Australian Resorts. It was Alan McGregor.
Alan McGregor. All right. Would that be a convenient time?
Yes, we'll come back at 11:30.
All rise.
seated. Thank you, Mr. Preston. Yes, Mr. Fuqua.
May it please the Commission. Mr. Preston, just prior to the adjournment, I was asking you some questions about the budget process for Crown Perth. And we're dealing, I think, at that stage with responsible service of gaming, which is one of your areas of responsibility. Do I take it that the answer to the questions about that would be the same where I'd ask them about the compliance role as well?
That's correct. It was the same process.
And within compliance, what was included in that area? What specific functions? Did it include audit, or was it just a compliance role?
They were separate areas.
So there was a budget for compliance, correct?
There was a budget for legal, regulatory and compliance as one budget. There was a budget for internal audit, which had internal audit and risk in one budget line. There was a budget for responsible service of gaming, and then there was a budget for AML as well.
Okay, so there was a separate budget for AML, CTF.
There was ultimately from 2017. It sat within other departments, but then we drew it out, as I recall, for a separate budget.
Okay.
If I recall correctly.
Yeah, were you responsible for the AML CTF budget as well?
Yes.
So you were responsible for, I'm going to call it RSG, responsible service of gaming, legal compliance, legal regulatory and compliance, AML CTF. What about internal audit? Who was responsible for the budget for that?
I assisted in the budget. There was a reporting line to me regarding internal audit from an administrative perspective, but there was a direct line to the CEO. So I assisted with the budget preparation from an administrative perspective.
Okay. Now, can I just take you to paragraph 9 of your statement? You recall earlier you deleted the words government and. Which was dealing, so I think, just to go back one step, internal audit and risk were part of the same budget.
Sorry, I'm mistaken. Historically, risk was within the broader legal and compliance and regulatory budget.
Right.
Audit was a budget on its own.
Right. Okay. Now, coming back to the words you deleted, government and, so it should just read public relations. What falls within public relations responsibility?
Corporate communications, community engagement, sponsorship, and general public relations related matters.
And was there a role or was there a position that dealt with government within Crown Perth?
That was the role was dealt with by a number of people, including myself, including Mr. Felstead, depending on the relevant government sector that was being dealt with. For example, human resources, they would deal directly with relevant government departments and the like for human resources related issues or health and safety related issues. But generally speaking, the reference to government from my perspective was dealing with the regulator.
Dealing with the regulator?
Dealing with the regulator.
And by that do you mean the Gaming and Wagering Commission?
And the department, yes.
And the department. So I was going to ask you then, so the regulatory function in the legal regulatory compliance, then what aspect of, was there no aspect of that involved liaison with the regulator?
No, I don't know if the terms are confusing, but it was a general descriptor in terms of my areas included government relations, particularly with respect to the gaming regulator. Regulatory function specifically was dealing with the regulator as well, particularly the department, dealing with day-to-day and other regulatory specific matters.
All right, just so I understand the distinction, because I'm not sure I do.
I don't think I've explained it very well, that's most probably why.
starting with the regulatory matters, plainly you had responsibility for that,
Yes.
and in that role, to some extent, you would have been required to deal with members of the regulating authority.
Yes.
When you're referring to government relations, is that a reference to contact outside the strict regulatory environment?
Yes, it can include that, yes.
And so what falls into that context? Is that things like policy?
Yes, there would be discussions pertaining to policy that would be in my area. But again, it was being dealt with by people within my area as well.
Okay, so you were dealing with it, but you're saying you didn't have responsibility for it. Is that?
No, I'm not saying that. I'm saying that it was the denomination in terms of government relations. All of the issues pertaining to government from a regulatory perspective would come through my areas. And my guess is an historic reference to the role that I was playing in that we would deal with regulatory matters. And because I was the most senior person there, I'd be dealing with what would be referred to as the government-related matters as well. So dealing directly with the Gaming Wagering Commission. And it wasn't me solely. It was other senior members dealing with the regulator or Gaming Wagering Commission. It was just a denomination, I suppose, within the various functions that I held.
All right, so I just want to... the deletion of government, what were you intending to convey by deleting the word government?
When I drafted this, originally it was called Government and Public Relations, and that portfolio moved from me, but only to the extent that it involved public relations. So none of the government or regulatory stuff moved. That's the only point that I was trying to make.
It's nomenclature. It's the internal way in which you refer to it in Crown Perth.
Yes.
You did not have that tag associated with your role internally.
Not the public relations after
Right.
2015.
But you're not suggesting that you had no role to play in interactions with the government departments and the GWC?
No, hence the reason I've deleted that, because that gave an indication from 15. It changed, but it didn't for that perspective.
Thank you for that clarification. Regarding the, can I ask you just draw your attention now to paragraph 21 of your statement, and this is in a related matter dealing with those people who reported to you. Before I ask you a question about that, when you were, I take it, promoted to the role of Chief Legal Officer at Australian Resorts, did that involve a relocation to Melbourne, or did you remain based in Perth?
I lived in Perth on the weekends, and I commuted to Melbourne most weeks for normally 3 to 4 days a week, and then often one day back in Perth.
I see. So did you have your own office in the Melbourne
Yes.
premises? And did you, as a consequence of that, did you take up some form of residence in Melbourne as well?
I lived in the hotel.
Oh, you lived in the hotel? Okay. Of course. And so would it be fair to say you divided your time between the two locations, but predominantly spent your time in Melbourne during the week?
It ebbed and flowed, but I spent more time in Melbourne, certainly, physically in Melbourne. But like a lot of businesses, there was an enormous amount of time communicating with video link and the like between the properties.
I understand. Now, it would be fair to say that the Melbourne operation is somewhat larger than the Perth operation.
Yes.
And so with the promotion role, did that mean you devoted more of your time to the Melbourne operation than the Perth operation?
That was certainly the outcome as a result of a number of matters that were occurring in Melbourne when I started.
Okay. Now, in the case of Mr. Felsteed, to your knowledge, did he relocate to Melbourne or did he remain in Perth?
He had largely the same arrangement as myself.
And did that mean you spent a fair bit of time to get on aeroplanes, did it?
Far too much time. Planes full stop.
All right. Now, can I just ask you then to identify the location of some of the people in paragraph 21 and which office they belong to. So I think Mr. Murray's in Perth.
Yes.
Sasha Grist,
Perth.
Brian Lee,
Perth.
Drew Stewart.
Which was Melbourne.
We say was, has left the
Sorry,
organisation.
he's left the organisation.
Okay. Sonia Bauer,
Melbourne.
Michelle Fielding,
Melbourne.
Anne Seegers,
Melbourne.
Louise Lane,
Melbourne.
Nicholas Stokes,
Melbourne.
Jan Williamson.
The next three are all
Yeah,
Melbourne.
obviously they're all Melbourne.
Yes.
All right. So the first three are Perth and the balance are based in Melbourne.
Yes, and of that, 5 of them held group roles.
Yes. Group here referring to Australian Resource.
Yes, so.
All right. Now, trying to understand the structure, there's a degree of replication between many of these committees in Perth and in Melbourne that you sat on. But trying to focus on Perth, if I may. The AML CTF committee, my apologies, it will take you to paragraph 22 of your statement, and I'm on page 10, paragraph G. It indicated it was established in about 2018. Was there a committee that specifically dealt with AML CTF matters before then?
The committee that dealt specifically with those matters was at the Executive Risk and Compliance Committee, and there was information that would be fed in to that committee as a result of the AML officer preparing papers through me.
I see. So from 2018, there's a structural change. There's a specific committee
That's correct.
established. And where was that committee based?
Perth.
So you're just speaking here about Crown Perth.
I am, yes.
Was there an equivalent in Crown Melbourne?
There was a committee of this form established at the same time in Melbourne, which was a new form of committee that was already in Melbourne historically.
Right. Now, were you chair of the AML CTF committee?
No, I wasn't.
Who was the chair of that committee?
The Group General Manager of AML.
And was that Louise Lane initially and then Nick Stokes?
That's correct.
All right. Now, I think you said, so it effectively reported to the ERCC, which is the Executive Risk Compliance Committee.
Yes.
And there was one of those in Perth and one in Melbourne, correct?
There was one in Perth for a longer period of time and one more recently in Melbourne.
Right. And you sat on both of those?
I chaired both of those committees.
Yes, you chaired both of them. So turning to Perth again, and this is I, 11, page 11. Where was the composition of the ERCC, if you like, permanent members and then invitee members, typically?
Yes.
And of the permanent members, you were the chair,
Yes.
and who else was a permanent member?
The whole of the Crown Perth Executive.
And by that, do you mean CEO
Yes.
of Australian Resource, as in Mr. Felstead?
Yes.
The COO?
Yes.
And at the time, that was Mr. Bossy, was it?
He was COO Gaming, and his title changed to, I think, just COO, but he was on a permanent member.
He was a permanent member. Obviously, you were a permanent member. Mr. Who else?
The Chief Operating Officer of Food and Beverage and Entertainment, the Executive General Manager of Hotels, the Executive General Manager of Human Resources, and there were some group executive roles as well. The CFO Australian Resorts was a permanent member.
Mr. Barton,
Mr. McGregor.
Mr. McGregor. Was Mr. Barton on the committee as well?
He was an invitee to. It changed historically. There would be a separate report with all of the papers would be provided to Mr. Barton and Mr. Nielsen, and there'd be a separate meeting held with Mr. Barton and Mr. Nielsen to take them through the papers. But they didn't attend the meeting with the rest of the executives. That changed in 2017-18, when Mr. Barton and Ms. Manos attended the meetings and participated in the ERCC meetings.
And did they attend in person usually or remotely?
It depended. Often in Perth, remotely. But if I recall correctly, Mr. Barton did attend a couple. He was here.
All right. Now, just remind me, Mr. Barton's position at this time was CFO
Crown Resorts.
Resorts. Mr. McGregor was CFO of Australian Resorts.
Time, yes.
At the time, I see. So there were either by separate meeting or by invitation and attendance, two executives of Crown Resorts participating in the Perth ERCC meetings.
Yes, that's correct.
Was there a direct line of reporting from the ERCC to the board of Crown Resorts?
No.
Was the purpose for which each of the executives from Crown Resorts either got a separate briefing or attended meetings to ensure the Crown Resorts corporate structure, as in the corporate entity, was informed of the deliberations on the ERCC?
I don't think I can answer what their position was with respect to it. From my perspective, having Mr. Barton and Ms. Manos across the issues that were being dealt with, particularly since Mr. Barton was a director of the Burswood companies and Ms. Manos was co-company secretary. Our view was it was an appropriate governance arrangement, so the information was being provided to an array of people.
All right. The practical effect, though, was that at least two executives of Crown Resorts were being informed via their participation, either directly or indirectly, in the ERCC of the deliberations of that committee.
Yes.
Now, the ERCC reported to the board of Burswood Limited.
Yes.
And can you explain the process by which the papers were prepared for the board of Burswood Limited?
Post the meeting of the ERCC, there would be at times amendments required or follow-up items post the discussion on all the papers. If those matters were attended to once they were settled, there would be various extracts from the papers that would form part of the legal risk and compliance and audit papers. And it was the key and material matters that would be prepared. They would go in draft to Mr. Felsted, and historically Mr. Craigie and then Mr. Alexander for review. And then they would be settled and they would form part of the board pack.
Okay, now, was it your responsibility as chair of the ERCC to prepare that paper for review by Mr. Felsted, Mr. Craig, or Mr. Alexander?
It certainly came from me in final format, yes.
So people within your group, presumably it wasn't you every time, but people prepared it,
Yes, that's correct.
you settled it, it then went on to someone else.
Yes.
So the decision as to what information from the ERCC made its way to the members of the board of Burswood Limited was made by a combination of you, Mr. Felsted, and the chair for the time being of the board of Burswood Limited.
Yes, and I can't recall because of timing, but Mr. Barton may have also looked at the papers, but I can't recall whether that's my memory. Him looking at them after it became CEO, or in his capacity of getting briefed in the capacity of CFO.
Would it be fair to say that by the time the board papers had been prepared and delivered to or distributed to the members of the board of Burswood Limited, the only members of the board of Burswood Limited that were unaware of the activities of the ERCC were the two independent directors? All others participated in the ERCC meetings, did they?
Yeah, yes, that would be, save for the chair.
The chair being Mr. Alexander.
Mr. Alexander.
Or Mr. Yeah.
Yes.
Okay. I just want to ask you some general questions that about risk and responsibility in the context of a casino licensee. And perhaps before starting on that, when you joined Crown Perth, prior to that, did you have any experience with respect to, broadly speaking, risks and vulnerabilities of casino operations?
No.
I take it that over the course of many years involved in the business, you were educated about those things.
Yes.
Now, as part of, I'm now speaking broadly about casinos, not specifically about Perth. As part of their operations, they offer gambling for entertainment, but they also undertake various activities that are similar to those of a financial institution.
I would agree with that, yes.
Yes. So, and just to be clear about what we're discussing, they accept funds on account. They open accounts for internally, at least for patrons, and they conduct money exchanges and transfers and things of that nature. So they have a financial institution-like function.
There are some elements of it that reflect that, yes.
Not all elements, but
Yes.
many similar features. Now, would you agree with me that a casino operation is a cash-intensive business,
Yes.
and that the cash-intensive nature of that business makes it attractive for criminal elements of society?
That's a vulnerability, yes.
And would you agree with the proposition that casinos are targeted by criminals for criminal influence and exploitation?
They can be.
Yeah, they can be. I'm dealing with this at the total level of generality and vulnerability,
Yes.
therefore potentiality. So now, again, at the level of generality and vulnerability, do you accept the proposition that criminals will attempt or may attempt to infiltrate or influence casinos to facilitate various criminal activities such as theft,
Yes.
fraud,
Yes.
money laundering,
Yes.
and other possible crimes, like loan sharking or distribution of drugs on the premises?
Yes.
Now, the Perth casino specifically is vulnerable to those attempts by criminals in the same way any other casino is vulnerable.
Generally speaking, yes.
Now, would you accept the proposition that if, and now I'm speaking to you as a person who is appearing before the Commission, has been involved in the operations of the Perth casino and the Melbourne casino for many years, no longer employed by Crown Casino. So as the individual, if criminals are permitted to successfully infiltrate the Perth casino, would you agree that may undermine public confidence in the trust in the credibility and integrity of the casino operations?
Yes. However, it depends on the circumstances.
Okay, just explain what you mean by that. Do you mean the gravity of the extent or nature of the infiltration?
The nature and the circumstances. It's a relatively broad statement you put to me.
Yes.
I'm trying to be
And
constructive, but
I understand.
it is a very broad statement.
Yes, and I did put it to you at the level of generality.
Yes.
Subject to that qualification that gravity or magnitude may affect the outcome of the effect on public confidence. Do you agree with the proposition that I put to you?
With some broader circumstances, if you consider the broader circumstances of any infiltration of that nature, for example, if the employee was complicit, because there's a whole range of circumstances where this could occur. But generally speaking, I would agree with the proposition.
Well, if I could put it slightly differently then. If a casino licensee took no measures whatsoever to take steps to prevent infiltration by criminals, that is something you would expect to undermine public confidence.
I agree with that, yes.
If appropriate measures are taken and nonetheless there is some infiltration, that's a different matter.
Yes.
So I just wanted to understand your sense of the responsibility of the casino licensee.
Yes.
So in a similar way, and again at the level of generality, and feel completely free to qualify any answers to these questions in the way you wish. While casinos offer gambling for entertainment, would you agree with the proposition that gambling can result in harm to some patrons?
Yes.
And the harm may take a number of forms, but primarily they can develop an addiction to gambling.
Yes.
And addiction to gambling can lead to financial hardship.
Yes.
And it may sometimes lead to mental illness as well, or may be the cause.
Yes.
Would you agree again, feel free to qualify this in your answer, with the general proposition that causing harm to patrons through gaming activities may undermine public confidence in the credibility and integrity of the casino operations?
I would agree, specifically if those services are provided in an irresponsible manner. So
Yes,
same kind of
point.
qualifications as you expressed
I
before.
understand. So, and the qualifications you've made, I think, are directing attention to specifically the role that the licensee has to play in maintaining the public confidence. Correct? Now, and again, I'm just going to deal with this broadly because we don't need to delve into the intricate details of how services are provided. But broadly speaking, the Perth Casino offers two categories of gambling services: table games and electronic gaming machines.
Yes.
Now, is it your understanding that patrons who regularly play on, I'm going to call them EGMs or electronic game machines, have a higher risk of developing a gambling addiction?
In very general terms, yes, that's what the research indicates.
All right. So then, would you accept the proposition that when offering gambling services through EGMs, it carries with it a greater responsibility on the part of the licensee to address the potentiality for addiction to those machines?
General sense, yes.
Okay, now, in terms of, I just want to ask you a few questions around the structure of the risk management framework you have described in your statement. So, as I again, I'm not going to take you to every paragraph because it's quite a few, but I'm just going to give you just an overview and you tell me if I'm wrong about this. Broadly speaking, there was a risk management framework whereby risks were identified, a register was prepared, and controls were identified to control the risk in a way that brings it down to an acceptable level.
Yes, I'd agree with that description.
Now, the risk management, in other words, the development of the risk register, and I've seen reference to something called CURA, C-U-R-A. Am I right in thinking that's the risk management program or software that's utilised by Crown Perth?
That's the IT solution or IT program which the risk information is loaded into, together with other, it holds other areas' information as well.
All right. Now, at the time you joined Crown Perth, was that system I've just described already in place?
No, it wasn't.
Okay. Can you tell me approximately when that system was developed for Crown Perth?
I would have thought it would have been sometime 2010 to 2012 or 13.
All right. So, I mean, that probably reflects a general trend, if you like, in the corporate world towards risk management practices.
I'd agree with that.
Were you responsible for the development of the risk management framework for Crown Perth?
That was a portfolio that I was responsible for.
All right. Now, given you were there at the inception, by what process was the risk register prepared? And by that I mean, was there for instance, a session at which members of management and or directors attended and brainstormed potential risks?
The process was the dedicated risk person would meet with the departmental managers and their teams. They would explore the risks associated with their part of the business. They would define what that risk was. They would identify existing controls. They would identify controls necessary to be implemented. They would identify any emerging issues, and they would build a risk profile against that backdrop. That would then be developed with the next level up in management to ascertain management's views of those departmental risk registers. And that was rolling all year, essentially, working through each of the risk registers on a periodic basis. Those departmental risk registers were then compressed, as I recall, into corporate risk registers. And those corporate risk, I use the term register and profile interchangeably, those risk profiles were then presented to the relevant executive and senior general managers, where there was, again, a critique of the risk information, and a challenge to that information, an assessment of status of controls that were to be implemented, and then once those profiles were settled, they would then form part of the Executive Risk and Compliance Committee, and they would be, the profiles were in every quarter, but every annually there would be a full review of each and every risk, which comprised a lengthy Executive Risk and Compliance Committee meeting with the whole of the executive that would go through all the risks, change in risk profile, change in consequence and likelihood associated with any particular risk or emerging risk, and then those risk profiles, as I recall, form part of the board pack on a regular basis, but it didn't involve the whole board in that discussion.
All right, now, can I describe that possibly as a bottom-up approach? So you're starting at the operational level, people identifying risks, and then by process of refinement, you summarise, effectively reach a summary of the various risks through the process you've described, and then management took a role in reviewing, and I take it forming a view about whether the controls for risks of a certain critical or heightened risks were adequately controlled. Is that a fair summary?
Largely, I wouldn't describe it simply as a bottom-up. The executives and the general management who were involved had critiqued them hard, so I describe it as a bottom-up and a top-down, and that they would go back to the relevant departments or back to line management to appreciate issues pertaining to risk in their areas.
And did the overall system and risk register make its way to the ERCC at any point in time?
Yes, the ERCC was well versed in the risk. The risk papers were put in every ERCC meeting, together with the annual review process we went through.
And was the annual review and the initial implementation a matter that went to the board of Burswood Limited?
I can't recall, sorry.
Were there any discussions or sessions in which what I might call strategic risks of the Perth Casino were identified and discussed?
In any particular environment?
In
or
any particular area, any particular environment?
Definitely at the Executive Risk and Compliance Committee. There were often discussions pertaining to the high-level strategic risks. And there were discussions at the board level pertaining to risk issues as well, in terms of key threats to the business, and what Crown would be doing, management would be doing to manage those to the satisfaction of the board.
All right, you might recall you asked some questions around the phraseology risk appetite or risk tolerance.
Yes.
In your view, who determined the level of acceptable risk for Crown Perth?
Well, again, as you've referenced, the concept of risk has evolved dramatically in the last decade. Risk appetite and risk tolerance, maybe it's my memory, but I can't recall them being specifically referred to initially. But what did evolve through the development of the framework was the consequence of the risk matrix, which was your likelihood and consequence, which was setting your qualitative and quantitative positions pertaining to what the business was willing to accept, where risks sat against an analysis against the likelihood and consequence impacts, and that was the articulation of appetite and tolerance. But it wasn't overtly called out. It was embedded within the documentation. And that's how risk appetite and risk tolerance lived for a long period of time. And then more recently, there's been a more overt statement pertaining to risk appetite and risk tolerance.
Okay, so let's just take the two periods then. The period during which there was no overt statement, but it was, as I think you said, buried in the documentation. When did, in general terms, when did that period end, and when was the more refined version?
From 2017, one of my projects was to review a number of frameworks, but risk being a key one of them. So from 2017 onwards, that was a detailed review of the whole of the risk frameworks for Perth and for Melbourne, which resulted in a detailed, articulated appetite tolerance position and also a new risk management strategy.
And when you say detailed, articulated tolerance statement, in what form did that take? What was the... Where does one find an expression in writing of the risk appetite of Crown Perth?
Well, we put a paper to various boards because it was capturing Melbourne and Perth, which articulated that very point, the appetite and the tolerance, together with a detailed risk management strategy, which also included in that the overt commentary pertaining to appetite and tolerance.
And in your view, what was the risk appetite of Crown Perth in that period? In your own words, what would articulate it?
I find that hard to articulate because the risk tolerances were varied depending on the relevant part of the actual risk process. So the risk tolerance for issues related to staff were described at the tolerance levels at a particular point. Risk tolerance levels pertaining to infrastructure were described in a different manner. So I'm not sure I could really describe it generally speaking. It's a collective position, the whole of the information presented.
All right, so there could be, to understand from that, there could be different levels of tolerance for risk depending on the nature of the activity in which Crown Perth was involved.
That's correct.
All right, so when one is dealing then with the vulnerabilities I described, I addressed earlier, we dealt with earlier, is there, to your knowledge, a written articulation of Crown Perth's risk appetite when it comes to infiltration of a casino by criminals?
I'd have to refresh my memory with the relevant risk documentation, but it would be captured within the departmental and corporate risk registers with their careful articulation as to what the risk might be and how to control it. And to the point regarding criminal infiltration, Crown's appetite to criminal infiltration was at zero tolerance. That was policy we had, and that was the way that the various control measures were structured around that.
All right. In terms of zero tolerance, I mean, there are different ways in which this can manifest itself. I'll give you an example to understand what you mean by that. So let's say, for example, a person applies to be a junket operator at Perth. I know they're not doing junkets now, but let's just use this as an example. Applies to be a junket operator at Perth Casino and the person has been convicted of a number of, you're known to have been convicted of a number of crimes in connection with money laundering, say for example, to what extent would that person be approved to be a junket operator for Crown Perth
My view is they shouldn't be approved,
at all?
not if they've been convicted of money laundering.
Okay. So what if a person has been charged with an offence of money laundering but not yet convicted?
Well, it would depend on the circumstances.
So the fact of a charge of money laundering would not necessarily rule the person out from operating a junket at Crown Perth.
Well, it would, in my view, would be a very clear red flag, and there would be need to be compelling reasons why they would be a junket operator.
Okay. What if there was simply information circulating publicly that the person had connections to organised criminal gangs?
It would require an investigation into the nature of those allegations as to the veracity of them or not.
Okay. So coming back to zero tolerance then, there's an element of judgment involved in what that means then, isn't there? In that rumour or unsubstantiated allegations of criminal activity would not meet zero tolerance in your view?
Again, it depends on the circumstances. If it's overwhelming, then the position should be clear. But if there's explanations or further information that's relevant, all I'm saying is that these matters need to be considered.
Okay, now just so we understand, I'm obviously speaking here about at the time that you were an employee, broadly speaking, of Crown Perth.
Yes.
So do I take it the answers you've made are from the perspective of you, when you were an employee at that time, what level of tolerance there was for that kind of risk?
Yes, that was the process that was in place at the time.
All right. Now, in terms of the risk management process more broadly, you have described the mechanisms by which risks were identified and controls put in place. I think you've described also some aspects of monitoring the risks. So, for example, audit is an example of a monitoring process. There was an internal audit.
Yes, there was.
And an external audit.
For financial measures.
And what did internal audit encompass?
I'm not sure I
Well,
understand.
what areas were... Sorry, let me take one step back. Addressing now the specific vulnerabilities of criminal infiltration, what areas of internal audit dealt with auditing of activities that controlled those risks?
As an example, they would audit security, they'd audit surveillance, they'd audit cage and count, they would audit food and beverage and accounting, food and beverage pertaining to the financial transactions. They would audit the AML program. So their audit profile through their strategic plan was across the business.
And who was responsible for developing the strategic audit plan?
The internal audit department.
And did you have a role in that at all?
As part of the executive, I would see the plan and I would have the opportunity to review it like all of the executive, and it was presented to the Executive Risk and Compliance Committee as part of the papers for discussion and or approval.
Okay, now, so who specifically was responsible for identifying what aspects of each area would be audited as part of the strategic audit plan?
It was a combination of the relevant executive, the general management, and other people relevant to those areas.
Okay, so if we take AML CTF as an example, was that an area where you would have been consulted
Yes.
on developing what to be audited?
Yes.
And was the process of developing the audit for, and I'm now speaking specifically about AML and CTF, did that involve having an understanding of the operating procedures of the Perth casino
Yes.
and the elements of obviously the AML CTF program that related to those operating procedures?
Yes.
So do I take it from that you had an intimate knowledge of the AML CTF program
I had a good knowledge of the AML CTF program.
and the operating procedures of each department of the Perth casino that were exposed to an AML CTF risk?
I had a working knowledge of departmental procedures.
And, all right, what about the casino manual? You know what I'm referring to there, the casino manual.
Yes.
Were you very familiar with its terms?
I'd been through it a number of times and I was familiar with its terms.
And I expect that in your role as AML CTF compliance officer, you were specifically familiar with the areas of the casino manual that dealt with AML CTF matters.
Yes.
Now, after an audit was undertaken of, and I'm talking about general procedure now, not anything in specific. After internal audits were undertaken, from time to time, non-compliances with internal procedures were identified, were they not?
Yes.
And after let's assume, I'm just talking in a general again, there's identification of a non-compliance. What was the procedure for dealing with, and I know this may depend on the gravity of it, let's say there was a non-compliance in an area of relatively high risk. What was the procedure for dealing with a non-compliance of that character?
In general terms, if it was
Yes.
a material issue, it would be brought to the attention of the general manager as to the issue, and it would, again, depending on the issue, it would more than likely be raised with the executive responsible for that area, and there would be a rectification plan required or response required as to how to address it, and also an understanding of how it occurred.
All right. Now, would that information you've just summarised appear in any document that made its way to the ERCC?
Yes, often the internal audit reports I can't recall off the top of my head whether all the internal audit reports went to the ERCC, but they all went to a distribution list, which was always on the front cover of the internal audit report, which included the executives, and if it was a finding of if the actual internal audit was a significant or severe, I can't remember the categories, it would also be provided to the CEO.
All right. Now, I think I don't remember the exact phrase you used, but it was to do with a rectification of whatever was found to have been the non-compliance. So I think plan, you said maybe it's a rectification plan was the effect. So sometimes things of that nature are referred to as corrective actions or
Yes.
action plan. Right? So whatever your internal reference was, where were they recorded?
They were in the internal audit report.
And the specific nature of the corrective action, where was that documented?
In the internal audit report.
And was there a process by which the organisation was able to keep track of implementation of corrective actions?
Yes, there was. There was two ways, one of which internal audit had a process which was a follow-up audits. So they set a timeline, as I recall, to follow up on any action items that needed to be considered, and they would follow up over an agreed period. They also, as I recall, had a spreadsheet which listed all of those items across the business that were being managed, and being worked through, and a status of how they were progressing and deadlines and the like.
All right, who had control of that spreadsheet?
Internal audit.
And was the progress against corrective actions or actions recorded and brought to the ERCC?
As I recall, it was, if I recall correctly.
And what about the board of Burswood Limited?
There was an internal audit report with each board meeting. I can't recall whether the narrative in there included, if I recall correctly, it did include status of rectification details. It might have been a higher level set of commentary as opposed to the granular piece. I can't recall.
All right. So if we have regard to the ERCC packs and minutes, we ought to find reference to the kind you're referring to.
Yes, if I recall that that information was included.
All right. Now, just in terms of risk management, again, just in talking in generalities, are you familiar with the phrase lead indicator and lag indicator?
Yes.
So, audit is essentially a process by which you identify lag indicators.
Yes.
Was there any process by which Crown Perth sought to identify lead indicators? That is to say, for instance, did use occupational health and safety, near misses and things of that character, specifically addressing vulnerabilities of the casino into criminal infiltration?
Not with the science associated with near miss, using your example.
All right. So, what sort of lead indicators did you have regard to then?
Well, there was we had what I would describe as lead indicators come through our compliance framework, in that they would often talk or have reports pertaining to issues related to compliance, and they were often minor issues, but through debate we often saw them as lead indicators as to particular trends, which is a bit different to the lag element. That would be my best way of describing where I'd see lead indicators.
If we go back to the example I gave earlier concerning a junket operator, would it be possible to characterise someone who'd been charged with an offence, or there was public knowledge of or notoriety of association with criminals, as a lead indicator?
Yes.
Was any consideration given to adopting a framework for lead indicators of that character?
Not at my time. I started to play a role with the junket approvals from about mid-2017, and the depth of information being provided had increased as part of a revamp of the process, and those details would be considered by 3 senior people, and those were key considerations when that information came to our attention.
All right. Can I ask you to turn to your statement? I want to go back now to an earlier section that dealt with governance. And you have used the expression a few times, and you've used it again today, that Burswood Limited was the board of moment. I just want to understand what you mean by that expression.
As I attempted to explain before, that was the board that met on all of the matters pertaining to Crown Perth.
All right. So do you mean by that it's the one that held formal meetings, it had board packs, and it convened with the independent directors?
Yes.
Now, that board met about 4 times a year,
Yes.
and the duration of meetings, would you accept, were around an hour?
That would be the average, yes.
Now, as a matter of general a general proposition, would it be fair to say that well, can I go back one step? The minutes of the meetings were the first item, the previous meeting, were the first item on the agenda for the next meeting.
Yes.
And inevitably those minutes were passed with or without corrections and signed by the chair.
Correct.
And again, the level of generality, would you agree that the minutes, presumably you were the person responsible for preparing them,
Yes.
and that they are, generally speaking, an accurate record of what transpired at the meetings?
Yes, to best of my ability.
Now, have you can you recall, again in a general sense, that the nature of the discussions at those meetings, and again you can feel free to disagree with me, largely centred on the financial reporting and the CEO's report?
That would be more time spent on that than other items.
Okay, now, and that's reflected, generally speaking, in the way in which the minutes are recorded, as they often contain extensive explanation of what was said for those items and not much for some others.
That's, yes, the minutes, yes.
Right. Would it also be fair to say that at these meetings, generally, again generally, not always, but generally, the legal, regulatory and compliance matters and the internal audit matters were addressed by way of taking the reports as noted?
They were on a regular basis, and discussion would ensue on those reports with specific items called out.
Okay, so again, I'm not asking you to remember every single meeting you attended. I want to get, I'd like you to give the Commission a flavour for how these meetings ran and the extent to which, in particular, the independent directors were giving attention to internal audit and compliance matters. So, was it your experience that questions were asked of you relating to the legal, regulatory and compliance matters?
Yes, they were.
And what was the nature of the questions you were asked? Broadly speaking.
Broadly speaking, it would be further explanation on top of what the papers had articulated. It would be questions as to how an issue occurred. It could be a question as to how are these matters resolved. A question as to impact. There would be questions at times as to adequately resourced. So it's a flavour of almost anything, depending on the issue that was being considered.
And were you left with the impression from the meetings you attended that the legal risk and compliance reports were being read by all members of the board?
That was my impression.
And does that apply equally for the internal audit reports?
That was my impression.
And is it the case then, if you had given an explanation or there'd been any significant discussion about either of those reports, was it your practice to record that in the draft minutes?
Generally speaking, but depended again on the nature of the discussion.
And were there occasions when you were called upon to speak specifically to a report you had prepared?
Yes.
And how frequently would you say that happened over the period you were?
Relatively frequently. Specific matters within reports more particularly.
All right. Now, given the commonality of a number of the directors, in the sense that they were executives with you on other committees and so forth, who would it be fair to say those asking questions at board meetings tended to be the independent directors?
Not entirely, but they certainly asked questions because they hadn't been involved in the ERCC process. But questions were posed from from all of the members of the board.
Now, again, coming back to the formalities, and just dealing with as a general matter, if Burswood Limited made a decision that that required implementation, was it the practice to record that in a formal resolution?
If it was a decision requiring a formal resolution, yes, but most of the formal resolutions would have been related to Burswood Nominees Limited.
Okay, so if we take just to understand that, take for example the risk management framework and risk registers, etc. Which entity in the Perth group do you consider was responsible for managing the risk?
Burswood Nominees Limited.
And so, to the best of your knowledge, was there a resolution of Burswood Nominees itself adopting a risk management framework?
I can't recall historically, but more recently, as I recall, they did formally adopt the risk management strategy, which comprised an overarching position pertaining to the enhanced risk framework.
Okay, so and do I take it the answer to that question is because in your mind the legal person with the regulatory responsibility for managing risks is actually Burswood Nominees?
Yes.
So the decision makers at the Burswood Nominees level, however, would be, in all cases, executives of the Crown Perth Group, correct?
Yes, that's correct.
So, are you suggesting that any decision requiring resolution and implementation by the entity performing the casino operations, that is, Burswood Nominees, one would find a resolution to that effect in its records?
Technically speaking, I just can't recall all the resolutions that were made, formal resolutions that were made by Burswood Nominees Limited.
I'm just having some difficulty understanding how this operated in practice, because you have described the board of Burswood Limited as the board of moment.
Yes.
It met 4 times a year for approximately an hour. It's 4 hours a year to manage Perth Casino. It had 2 independent directors who asked you questions from time to time. But when it came to implementation of the actual, what the licensee was required to do, implementation occurred at the level down at the Burswood Nominees level. As I understand the effect of your evidence.
Well, the formalisation of adoption of a resolution occurred at the Burswood Nominees level for particular matters.
Yeah. Now, again, just from a legal point of view, as you would understand, the decisions are being made by Burswood Nominees then, are they not?
Yes, but not entirely independently. They're making their decisions, yes, in their capacity as Burswood Nominees Limited, but they've been privy to involved in the discussions of Burswood Limited with a broader array of people considering the issue at that point in time. The formalisation of resolutions required would be dealt with by Burswood Nominees Limited.
Let's say, for example, I suppose it doesn't really matter, because if the executives agree with something, it'll happen in any event, because they're both the majority on the Burswood Limited board and the only composition of Burswood Nominees. I was trying to hypothesise a situation where there could be disagreement with a proposition at the level of Burswood Limited and yet still be implemented by Burswood Nominees. For instance, if the 2 independent directors disagree on a particular course of action, you will not prevent Burswood nominees from undertaking that activity.
That's true. I never observed that, but that technically speaking, Burswood Nominees Limited would act in its own interests. Could
So-
act in its own interests.
Again, just to understand how this entity referred to as Crown Perth worked in practice, what say really did the independent directors actually have in the operations of Crown Perth?
Well, can my learned friend clarify whether he means in theory or in fact?
Mr Futrell.
Well, I'll start with in theory.
Well, in theory, they were involved in all of the discussions, but technically speaking, if the Burswood Nominees directors did not wish to adopt the position that Burswood Limited had, they were entitled to. That could happen.
And in practice,
I never saw that happen.
So in practice, are you saying there was generally consensus at the Burswood Limited level and then implementation at the Burswood Nominees level?
That would be in practical effect, yes.
So I'm still trying to understand what function or role really the two independent directors played at the Burswood Limited level.
Well, they were providing their independent positions pertaining to Burswood Limited.
So they were two voices on a board of 5 that may have influenced in some way the decision-making of Burswood Limited, correct?
Yes.
But you'd accept that if the 3 executive directors of Burswood Limited disagreed, their vote would carry the day at the Burswood Nominees level anyway.
That's the numbers that could occur.
So in theory at least, Crown Perth was an arm of the executive of Crown Resorts, was it not?
I don't agree with that.
In what way?
I'm not saying there's no relationship. That's obvious, but I'm not. That's not my view.
I'm simply saying there is no way the two independent directors could independently have changed the course of any decision that Burswood Limited made.
If it was a vote, then that's correct if they didn't have the numbers.
And they would know that as directors of that company, would they not?
Or they knew the positions that the people on the board that they sat with held.
Can I ask, are you familiar with the constitution of Burswood Limited?
I'm familiar with it. I haven't looked at it for a very long time.
Perhaps we could call that up. It's PUB.0026, .0002, .0001. Can I start by directing your attention to Article 3.20? Can we scroll to that, please? Now, you were the company secretary of Burswood Limited.
I was co-company secretary, yes.
To the best of your knowledge, was there compliance with Article 3.20 of Burswood Limited's constitution whilst you were its secretary?
Not to my knowledge.
Were you aware of this provision as company secretary?
I don't recall it.
Can you recall any discussion around whether or not to send notices to the GWC?
No, I don't.
Would you agree with this proposition that if a member of the GWC attended a meeting of Burswood Limited as an invitee, they would have opportunity to observe the deliberations of that company?
You just give me a moment to Reread it, please.
Could I ask for the witness to be shown what precedes that? Because I just see it refers to
Yes.
of such meetings, and it's not clear what that's referring
Yes.
to.
All right, just
Fair-
take it back.
Fair point, fair point.
Take it back to the previous page. Right.
I think that's relevant to your question.
Yes, it is.
Yes, I see that.
And so is it your evidence then that at no time while you were Company Secretary of Burswood Limited, notice of a meeting of directors was given to the GWC,
Not to my knowledge.
and during the period that you were a director, an officer of Burswood Limited, was there any occasion that you can recall a member of the GWC attending a meeting?
No.
All right, can we scroll back to clause 3.12? And I just want to ask you whether, in your view, we're dealing here with where central management and control are exercised. In your view, was central management and control of Burswood Limited exercised in Western Australia?
Yes.
And why do you say that?
Because the central management was focused in Western Australia.
And do you mean by that the physical location of the directors and the meetings?
This is referencing central management, not. Are you contemplating that's referencing the directors or?
I'm referencing where the business of the company is located, from where it's managed.
And I would suggest that it's managed from Western Australia on the ground. There are group roles that cross the borders, and others are domiciled over east. But from my perspective, central management of Crown Perth is from Perth.
Okay, so and it's easy to do this, I understand, to conflate Burswood Limited with Crown Perth. So when you're answering that question, and I appreciate the way you're answering it, you're equating Burswood Limited with Crown Perth, and in your view, central management and control of Crown Perth was exercised in Perth. Is that what you're saying?
Yes.
All right. Now, I ask that can I call up PUB .0016.0018.0001. Now, you've referenced this in your statement, and I think you have indicated, this is on page 27, that you became aware of the provisions in clauses 21.1 little r and 21.1 a in approximately 2017.
Approximately, yes.
Now, can I go back to the... It's probably impossible to juggle, so I won't. There were common directors in terms of executives of Crown Resorts who sat on both the board of Burswood Limited and the board of Crown Melbourne Limited, correct?
Yes, that's correct.
And they were Mr. Felsteed.
He wasn't on the board of Crown Resorts.
Was not on the board of Crown Melbourne.
He was on Melbourne.
And Mr. Barton was on the board of Crown Melbourne.
Yes.
and depending on the period of time, the CEO of Crown Resorts or the chief executive, the executive chair of Crown Resorts was on the board of Crown Melbourne.
Yes.
And those three individuals or roles also sat as the three executive directors of Burswood Limited, correct?
Yes.
Did it occur to you after you had considered these provisions of the Crown Melbourne agreement with the government there, that there was a potential for there to be a conflict between the interests of Burswood Limited on the one hand and the interests of Crown Melbourne on the other?
Not necessarily.
Not necessarily, but I'm talking about potentiality here. There could be circumstances where, for instance, it was not in the interests of Burswood Limited for there to be compliance with those provisions of the agreement in Melbourne.
Potentially.
To the best of your knowledge, and given that potentiality, that could feature in many possible decisions made involving Burswood Limited. It would depend on the decision, but it has a potentiality.
Can I trouble you to bring up 22(1)(r)?
Yes,
and
sorry,
RA,
I should have done
if I
that.
can see if that's right.
22.1R and RA, so you can highlight keep going all the way down to the end of RA.
Yes, can I get you to repeat the question if you don't mind?
There's a potential in many decisions that may take place at the Burswood Limited board level for the interests of Burswood Limited, let's call it Western Australia, to conflict with the obligation under the Victorian agreement to essentially prefer the interests of Victoria.
Potential with some of it.
That's right, but it's the potential. I'm only interested in the potentiality.
With some of it, for example, RA Roman numeral 3.
Yes.
So if Crown Perth was to become a larger, higher scale property than Crown Melbourne, that would be something that had the potential. That had been an issue.
What about R Roman 1?
Well, that's with respect to Crown Melbourne.
Yes, but it's to ensure that the holding company uses the best endeavour to ensure that the business is conducted in a manner which is beneficial to, essentially, Victoria.
Sorry, R1 or RA1?
I'm talking R Roman 1.
R Roman 1, sorry.
Drawing attention to both R Roman 1 and RA.
Yes. Well, there's more parts to Roman numeral 1 in that it's
Yes.
beneficial to both of that business. So beneficial to Burswood Limited, Crown
Yes.
Perth.
No, beneficial to that business being the business of the holding company, is it not?
No, my reading of it is that a holding company group, if it pursues in anywhere in Australia a business similar to that of the company. So
Yes.
my reading of that, it pursued Perth, it
Yes.
purchased Burswood as it was then known.
Yes.
So it's beneficial to Crown Perth and the company, which promotes which
Yes.
promotes tourism and economic development generally in the state of Victoria.
Yes. Is the second limb I'm referring to?
I don't necessarily see that in conflict with what Crown Perth would be doing.
Okay. Did you consider whether it was necessary to draw to the independent director's attention on Burswood Limited Board's the obligations of, or the provisions of this agreement?
No, it didn't. And I say that because when I came across this provision, when I changed my roles, my assessment, and I spoke to a couple of people about how this had been managed over the years, was that these matters had never been close to coming into conflict.
So, do I understand from your answer to that question then that you did recognise when you read it the potentiality for there to be a conflict?
Well, I saw it and I recognised that I wanted to understand, because I hadn't seen it before. It was new to me.
Okay, and who did you raise it with?
I spoke with, if I recall correctly, the Group General Manager of Regulatory and Compliance in Melbourne, to ask how they had managed this over the years. If I recall correctly, I came across it during the course of the sixth review that the BCGLR was undertaking in Melbourne. And she explained to me Crown's assessment of this over the years, particularly with respect to RA 2 and 3.
Yes. Now, do I take it from that answer then that the view that was expressed to you was because a conflict in the view of the person you spoke to had not manifested itself, it wasn't necessary to draw it to the attention of the independent directors of Burswood Limited?
I was satisfied when I read through this that I accept that there's potential. I accept that. But I was satisfied with the facts surrounding, again, particularly 2 and 3, which jumped out originally. Crown Perth was at a different scale. It was a different scale property with respect to the commission-based business. In Australia, it was a smaller property. Crown was by far a larger property. Crown Melbourne had by far a dominant commission-based business in comparison to Perth. Perth was very small in comparison to Melbourne.
All right. Now, if the potential for conflict had realised itself, is it your expectation that the executives of directors of Burswood Limited would have brought that to the attention of the non-executive directors?
Yes, that would have been my expectation.
For a convenient time.
Yes, thank you.
Sorry, can I just ask a question about that? It seems we've got it up on the screen. Putting aside the conflict, looking at R1, isn't there an obligation on CRL there to ensure that the Perth Casino is conducted in a manner which promotes tourism, employment and economic development generally in the state of Victoria?
Using best endeavours and...
so, leave it there. Wouldn't the best endeavours of CRL include advising the non-executive directors of Burswood Limited of that fact?
Yes, I accept that.
Thank you.
All right, we will resume at 2 p.m. Mr. President, 2 p.m.
All rise.